Good morning. My name is Mark Silver. I'm a forensics and mitigation specialist. I've done thousands of cases in the United States, primarily for immigration and criminal lawyers, but also for civil litigation attorneys. I've also taught continuing legal education programs to countless lawyers in the United States. And not too long ago, I started a YouTube channel, primarily so that the CLEs that I have presented can be available for free on the internet for anybody to see, but also to present some new material that may not be amendable necessarily to CLE context. I think it's still worth having them included in in this series. I'm a psychiatric social worker. I'm also a lawyer. To the embarrassment of my mother, I don't practice law. I've been a psychiatric social worker doing forensics for about 22 years now. I also have a background in psychology and political science. And as I said, I do CLEs as well. I testify and I write articles and books. Today's program is something that's been part of my work off and on. I've actually done cases in this area, and I've consulted on several cases in this area. And it concerns malpractice. And the topic today is avoiding malpractice and recognizing, in particular, difficult clients who may undermine their case. They may sabotage your work as a professional, as an attorney, and to how to better identify these individuals and how to have a better grasp of how to intervene and to protect yourself. There's a book that I usually mention in other contexts. It's Borderline Personality Disorder, Survival Guide from Chaos to Authenticity. It's on Amazon. I think everything's on Amazon these days. The reason I mention this book is because a lot of the individuals, a lot of the clients you're going to encounter as an attorney, if you're listening, or even as a physician or other professional that may be the target of malpractice or may have committed malpractice, we'll find that some of these individuals that are pursuing claims against you have borderline personality disorder, unstable personalities in different ways, and we could talk about that. And I actually have a completely separate YouTube program on borderline personality disorders. But the other book I want to mention is this, which is Psychosocial Evaluations and Consultation in Civil Litigation. It's really for all lawyers, though. And I mention it because I'm going to have a future program on how to conduct psychosocial evaluations, how to interview clients. And this book really helps lawyers understand how to elicit information from clients and gain their trust and have them feel secure so they can speak openly, often about rather difficult subjects. It's very important because law school is very short, right? It's 3 years that we have. And we don't have courses on how to deal with clients. We don't have courses on how to elicit information from clients. We don't have courses on how to handle clients when they become agitated or nervous or even threatening, either to themselves or to you as a professional or your law practice or medical practice or what have you. In fact, I remember when I was in law school, I think this is third year, I took a seminar, a health seminar. We had to interview other students in our seminar, and I did fine because that's my background is in mental health and interviewing people in clinical contexts. But some people had never interviewed or tried to elicit information from another person, and it's absolutely crucial for civil litigation lawyers, criminal family lawyers, really lawyers in almost every sphere of practice. And it's partly to gain information that you need from the client to understand how to help the client and what the client's issues are. But it's also to gain the client's confidence so that the client is not there just sort of scouting you out as a potential attorney, but so that the individual feels sufficiently comfortable, that they have sufficient trust and sense of confidence when they're speaking with you and you're speaking with them, that they will retain you for professional services. Obviously, there's some basics in every profession, including law, that really constitute, I would say, groundwork professional issues and guidelines in practice, including obviously know your subject, know the law, be very careful about deadlines, try to avoid errors, know about discovery material when it's appropriate, calendar, always remember statute of limitations and so on, avoid conflicts of interest, maintain confidentiality, and do your due diligence in whatever areas you need. Malpractice then is really, as it is with medical malpractice, it's a type of negligence, and the plaintiff has to show that the same elements are present as in regular negligence, which is that the attorney had a duty towards you, and perhaps the fee agreement or retainer you signed with the attorney for legal services proves this as a duty. The attorney breached that duty in some way. Losing a case is not necessarily a breach of duty. The breach was the cause of the harm you suffered, and you suffered some kind of financial or some other kind of injury. So I want to move beyond what you would normally hear in a CLE about how to move beyond what you would normally hear in a CLE about good ethical practice, to understand at a clinical level how to avoid malpractice and how to bolster your legal practice, or if you're a physician, medical practice, in a way that is not only more helpful in understanding the client, but is more helpful to you as a professional. The first thing I would say, and this may sound quite obvious, is that your client wants to be heard. Your client is trying to convey something about a legal matter, but at the same time, the client wants to be heard as an individual. They want a sense of sympathy for their particular problem. They want a sense of dignity. This includes, people that want to sell their home, for example. People are very emotionally attached to their property. They may have lived there for many years and raised family and had all sorts of very, very positive memories. They want the lawyer to understand their connection to that house. In immigration, criminal cases, certainly in civil litigation cases where there's been harm or injury, in med mal or in a personal injury and so on, it's not just that the client is presenting facts regarding a medical or physical harm as a result of an injury. The client wants you to understand that they have been hurt. There's something about them, their dignity, that has been undermined, and they want sympathy for that. They want just general understanding. One of the key areas that I work on is to humanize cases, to help lawyers humanize the case, meaning to put a face, thoughts, feelings, emotions, and so on to facts that may seem otherwise quite dry, to humanize the case. And when you do that, you have a much better avenue to present the case either to a jury or to your opponent or whoever. Many clients want you to understand their life story. Many clients at this point, when they come to you as an attorney, they may be under a great deal of stress, perhaps related to the immediate issue in the case. This is certainly true for immigration and criminal matters. But they may have adjacent stress because of other issues completely unrelated to the immigration or criminal matter that nonetheless significantly impact on their health and their well-being. Another thing that the client wants is that, you know a great deal as an attorney. You're very professional. You've gone to school. You're very educated. The client does not want to be condescended to. The client does not want to be spoken to like a child. It's important to be able to convey legal counsel and advice and suggestions about how to pursue the case and options and so on in a way that does not make the client feel belittled. They want to retain the sense that in some capacity they're working with you, that it's a partnership. They want to be informed, and some clients really enjoy frequent updates regarding their case. They may want to be told, as in medical practice, risks and benefits. Physicians are required to provide risks and benefits to a procedure. That's what the client wants in legal matters as well. They want a sense of how likely it is that what they're going to do will end up in a positive outcome. And if there's a negative outcome, how negative. Some clients really want a friend, they want a therapist. You may see clients that, quite frankly, are generally isolated, especially those that don't have strong family or community ties. And, they may really quite enjoy coming to you as an attorney just to say hello. And, you think that they want this update for their case, and really what they want is someone to say, how are you? What are you doing in your life? It's been a great summer. What have you been up to? And the person may use the opportunity, hopefully appropriately. If they use it inappropriately, that's something we're going to get to after, to create, a social bond. Obviously, if the person is approaching the attorney as a therapist or something beyond their professional capacity as a legal counselor, then you have a problem. And as I said, that's something we're going to talk about after. Many clients have issues also that they cannot sufficiently explain or understand themselves. And professional expression replaces self-expression. I've said this many times in many programs I've done. So, you may have a client who has, for example, a criminal issue or, an immigration issue, and they may have some familiarity with their case and their life history, but they can't explain it in a way that provides sufficient factual context to the legal issue at hand. And a very, common thing I see is asylum cases where an individual has suffered persecution, human rights violations in, his country of origin, and he comes to the United States and he can explain somewhat about his adverse experiences before relocating to the United States, but the client requires the lawyer to use the facts in the context of his legal claim of asylum in order to effectuate a proper application. And the last thing is some clients simply want to, I kind of mentioned this before, but regular communication. They want a sense that even though you're the professional, that you're keeping them in the loop. There are certain ways to talk to a client that's very helpful. I'm going to talk about this a lot more in my future YouTube program on how to talk to clients and how to conduct evaluations. But there are certain phrases and ways to engage with a client that help put them at ease and help them focus on what you're saying professionally. I often use such phrases as, I wonder. I wonder if what you're trying to tell me really has to do with this, or I wonder if there's some concerns you have about the case that you're not really talking about because they might be a bit embarrassing or painful to talk about, but it may be helpful for you to be open so that we can have a full understanding about what your case is. Another example is just using words like perhaps. Perhaps if we think about the case in this way, or perhaps if you consider this as an option, it may be another route we can take in pursuing your application. Another is reflective. You can use a phrase like, could it be that maybe you're coming in today not really to provide any more information about the case, but you're just a bit nervous because the court hearing is coming up next week, and you want to check in. Another is to check in with the client's own understanding of things. So, for example, you can say, if I understand you correctly, and then you sort of mimic or feedback, provide back to the client what you think the client has tried to tell you. Because often the client may be garbled, nervous, and so on, and you want to make sure that you do understand what the client is conveying. Um, you know, we see a lot of people that are successful. This is particularly true in white-collar cases that I've seen in criminal cases. And, quite often, people who are successful and more educated, they're good at hiding things. They're good at covering up. They're good at covering up things psychologically, emotionally, and in other ways as well. You'd be surprised how many successful people have alcohol and drug problems, but they're able to contend with their issues with alcohol or drugs in a way that does not seem to undermine their everyday lives. And it's important to really remember that just because someone presents very well, they may have very serious issues that they're reluctant to relay to you, or that they're relaying to you in a way that is not helpful to the case, and you need to redirect them in a way that they're calm and focused, and that the relationship is productive. One huge area, and I see this a lot in white-collar criminal cases as a huge example, is that you have people who have never been in trouble. They've never been arrested. They're quite trusting, and they're quite naive about the power of the prosecutor. They think that things will just work out for them because things have always worked out. Many of these white-collar criminals are they're educated. They've gone to undergraduate, graduate school. They've had a professional career. They're often married and have, healthy attachments not only to their family but to the community. And they think things are just going to work out, and things don't always work out in life, of course. Things can be, at times, very problematic. Some of these clients also have the sense that money is the solution. You hire a lawyer, you pay the lawyer a lot of money, things are going to work out. And of course, that's not always true. Many of the white-collar clients I see can sabotage their case. It can be quite difficult because they become, quite frankly, quite arrogant. They may be unapologetic for various reasons and quite demanding. This is also true in the immigration world, by the way. You see a lot of immigrants. I see them that I refer to my forensics practice, who are completely unfamiliar with any kind of legal system. They may have come to a place where there was significant poverty and lawlessness and corruption, abuses, crime, alcohol and drug abuse, and so on. And they're just really unfamiliar with the idea that there are legal procedures and steps to take that could be very helpful to the client, but they have to follow through. They have to have some faith in the system, and they have to work constructively and allow the lawyer, to do his or her job. You also find, very interesting, like I mentioned before, asylum cases. I'll have people who come here and they suffered persecution in their country of origin, and they could not conceive of a legal system in which there's an avenue to get a green card based on the human rights violations that you suffered. They grew up and were raised in a society or country where the human rights violations they suffered were quite ordinary, quite accepted, and there was no legal recourse. There's a very interesting three-pronged test for competency in immigration courts. I always use it as a overarching way for me to understand the degree and the ability of clients to participate in evaluations with me and even with their own lawyers. And the first is, does the client understand the nature of the process and the objective aim of the proceedings? That is, not only are you asking, does the client understand what they're going to be doing in court and the process of the court proceedings and what the aim of the proceedings, but with you as an attorney, does the client understand why they're really coming to you time and again to give information? Does the client really understand the aims and the objectives and what the outcome might be? For example, in civil litigation and personal injury cases, you may have an outcome that ends relatively quickly with a relatively small agreement from the defense because of personal injury in your favor. You may have a completely different kind of outcome that comes as a result of a court case that takes weeks and weeks, that occurs, maybe a year and a half after the original harm occurs. So you can have two very different kinds of objectives or aims that are possible, and the client needs to understand the process and the aims of all this. The next thing is, can the client not just present their initial issue to you as a lawyer, but can the client consult with the attorney on an ongoing basis? Can the client continue to provide information and update the lawyer? And most importantly, the lawyer is going to have a lot of questions from the client. Can the client reasonably provide information that qualifies and continues to explain the issue when the lawyer has questions? And therefore, is the client able, this is the third prong, to reasonably examine the evidence that perhaps stands against them? And would they be able to understand and provide answers to that evidence during perhaps a deposition or perhaps during cross-examination? One of the things that are key is indicators of serious mental health issues that suggest that client may be an individual who will undermine their case or somehow sabotage your work as an attorney, as a professional. And these are clients, and I'll give you some examples. A client who has difficulty communicating thoughts completely or coherently. A client should be able to explain, they don't have to use legalese and highfalutin language, but they should have a basic coherence to their thoughts and explain why they are there and the issues in a somewhat coherent manner, so that they're able to relate to the attorney, but so that the attorney can evaluate the facts that is being presented by the client, and so the lawyer can make a legal determination if there's a case to pursue. Another example is the client thinking in very simplistic, concrete ways? For many kinds of cases that lawyers see, especially for immigration and criminal world, but also for civil litigation lawyers, the more complex facts, the more details, the more specifics that the client can provide in explaining the case, the better the lawyer will understand what the case is or is not. Another major issue is, does the client present with impaired memory or obvious difficulty processing information? Another issue is, does the client seem disoriented when they come in to your office and they're speaking? Do they seem to have difficulty presenting the information not just coherently, but understanding where they are and why they're there? Does the client seem to become easily distracted? Do they have confusion in the facts they're presenting? Do they have inattention or even poor focus and so on? Are they very impressionistic? Do they easily cower? In other words, are these clients who will defer to another person and demur? They're very docile, and therefore they have difficulty proactively and actively conveying to the lawyer what these issues are that they want to talk about. And again, obviously the greater coherence and the greater detail the client has when conveying the case, the better the lawyer is able to understand the case and understand what the options are. But with individuals with perhaps serious mental health disorders, and we have to understand that psychiatric issues is reality for many of the clients that we see in the worlds of criminal and immigration law, that this can very much impact how they present the case and how the lawyer understands the case. And as a result, the lawyer should have an awareness of what the red flags are for serious mental illness. And number two, the lawyer should have a sense of safeguards as what to do. And I'll just give you one very obvious example. Have another family member. If you see a client who seems somewhat confused or disoriented, they're not quite coherent or presenting a picture that is complete in the way that you need to hear it as an attorney, you might say, I wonder if it might not be a better idea if you come in with your wife or you come in with a family member or a close friend can help you provide some information. There's something called a parallel history in clinical work, which means that, someone may present their psychosocial history which sounds great, but to gain an understanding of the person through a parallel history, perhaps a spouse, someone that's known the person for a long time, can be invaluable because the spouse will provide not just a perspective that the client himself may not be able to fully provide, but the spouse may fill in all sorts of blanks that the client may not provide because of forgetfulness, because of mental health issues, because of shame or embarrassment, and many other reasons. It's important to also understand, though, that just because a client has a real mental health problem, it doesn't mean that they're not competent. A person can suffer from clinical anxiety, depression, and all sorts of other mental health issues. It doesn't mean that they're unable to present a coherent narrative of their issues and engage and work with the client in a reasonably and even productive way. And it's the same thing with someone with a medical issue. Someone may have a very serious healthcare problem. It doesn't mean they cannot engage with their lawyer and work with the lawyer on whatever the legal issue is. So it's important not to be condescending or presumptuous when a person has a mental health problem about what limitations they may or may not have. At the same time, the opposite is also true. That is, the fact that someone is seemingly coherent and engaging, they seem like they're able to work with you in a reasonable way so that you can elicit information, it doesn't mean that they don't have very, very serious trauma or cognitive issues or limitations or even intellectual disabilities. I'll give you a very common example. I see a lot of immigration cases where people have come to the U.S. from Central or South America, and they have very limited educations, perhaps the equivalent of a sixth grade education or less. And they're here as immigrants with a family. They're doing quite well, often working one or two jobs. They're good community members and so on. And when I do the clinical evaluation for forensics for their immigration case, I have to remind myself again and again that although the person is cooperative and coherent and they're engaging, the fact that they have very limited educations may mean that, they may have limitations, perhaps conceptual limitations, and perhaps other limitations that make me very weary about making assumptions and being careful without being condescending, working with them in a way that makes sure that they understand what the issues are and making sure that I'm truly eliciting from them all the information that I really need. Another example, I see a lot of survivors of domestic violence. And some of these survivors have been separated from their abusers for months or even much, much longer. And they seem to be doing well. They're going to work every day. They engage with friends and family, community. They go to church and so on. And you think, oh, this person's doing quite well. The fact that they're engaging with you as a forensic expert very well or with you as an attorney doesn't undermine or doesn't preclude the possibility that they've suffered very serious trauma. And the serious trauma very much informs how they think and feel, and you may need to tap into that or be aware of it as a possible limitation to a full narrative that they could otherwise provide. There's certain core questions that I ask to always make sure a client is coherent and that they know where they are, such as, the first thing I always ask a client is tell me your name, even if I know the client's name. I do this for many reasons, especially in immigration work, because you have clients with 3 and 4 names. But I want to make sure the client knows the date, where they are. I want to ask them how I can help them how they got referred. I want them to explain in simple language their own issues. I want them to know or be able to explain to me their relationship with the lawyer that they've hired. The lawyers, in 99% of the cases, referred the cases to me, because I want to make sure that the client really understands the case, and the client understands the seriousness of the case and what the consequences might be and the process and so on. It's important not to assume anything about your client. That's another way that lawyers sometimes get in trouble. Don't assume that the client really understands what you're saying to them. Don't assume that the client, just because they're wearing, a $2,000 Giorgio Armani suit, is necessarily educated or successful. As in white-collar cases, it's important, just because the person grew up in a white picket fence home and they have degrees in a family and so on, that they're necessarily healthy, or that they're necessarily able to engage in a way that you really need them to engage with you in a professional manner. Another huge example that I see where clients go off is because things are just complicated. And I hate to go back to white-collar cases, but I see this a lot. You have cases where the statute or the law is overly complicated and frustration may ensue for the client. I see this in asylum cases where the client has suffered persecution in his country of origin, and to him, the law is almost like beside the point. He thinks like, the lawyer's trying to explain the law and what needs to be proven, the context in court or not court, and the client thinks, I've suffered this terrible persecution in my country of origin. It's just so obvious. Why do I have to deal with these crazy laws in the United States? But of course, that is what the program is all about. Another issue is that you'll sometimes see clients who view their illegal behaviors as normative. That's very common with some people who get into trouble, especially in white-collar cases, middle-class criminal defendants, and so on. In other words, they'll see their professional conduct as routine among their peers, and they become frustrated. The client becomes frustrated because they can't understand why it is that they're now in trouble. And the third issue is a complex set of facts. This is very common in wire fraud, white-collar cases, and so on. I see this in immigration cases all the time also, where immigrants have to prove that family members would suffer extreme and exceptional hardships if they're forced to leave the United States. And often the client will sort of focus on one or two things that they think are most central to the hardship analysis in the immigration case, but really there are a wide set of varied facts that pop up in different areas of analysis that are relevant. So there's a complex set of facts, and it's the responsibility of the evaluator or the lawyer or whoever to make it manageable and digestible for the client. Some clients may erroneously believe that they are entitled to a much better outcome that is offered in a plea deal, for example, in a criminal case. The client may demand unrealistic results from the lawyer while also ignoring the lawyer's best legal counsel. The client may pay a substantial legal fee and expect that it will magically bring a positive conclusion to the problem, even though the lawyer may indeed require considerable assistance from the client. In other words, it's not just that the client can drop, a legal fee and say, take care of my case. The lawyer needs ongoing assistance. I see this also as a forensic evaluator. The clients sometimes want to come and pay me what I ask, and they say, well, I have 20, 30 minutes, let's get this over with. And I'll say, you need to understand this is a very serious case. We need 2-3 meetings. They may be several hours each time. And I need you to be really patient. Let's try and work together. But to rush the case is not going to help you. It's not going to allow me to do the evaluation I need to really understand your background. And finally, clients may just be extremely naive for various reasons, and they may do things that undermine their case. A lot of these clients are angry, they could be irritable, they could be suspicious, anxious, they may be very unclear, controlling, and so on. And what I want to turn now is to specific character types or pathologies. Character types provide an understanding about how individuals with particular character traits interact with the world around them, with colleagues, families, and how that individual understands things from their own subjective or idiosyncratic perspective. And this ultimately really reflects what the individual understands about himself with regards to his own needs, emotions, thoughts, behaviors, and so on. And when you're dealing with difficult and demanding clients as an attorney or as a professional in general, it's helpful to know something about these different kind of character types. And one I'll mention first is the dependent type. The dependent type of person has difficulty making decisions on their own. They're reliant on others. They need others to assume responsibilities for them. They may have difficulty expressing disagreement with a professional. And they may also feel quite uncomfortable or helpless when they're alone. So such clients may unconsciously try to turn the lawyer into a parent figure, bring into the office perhaps insatiable needs for affection or attention, then becoming sulky and hostile when those needs are not met. Another type of character type is borderline personality disorder. As I said, I have a book about it, and I have separate, just showing you the cover again, separate program on it. But this is a key area for lawyers to understand. These are clients that often make complaints. They say, the lawyer didn't hear me, I was ignored by the lawyer, I was misunderstood. Many of these individuals have chronic dissatisfaction. They may make unhelpful suggestions, call the client every day. Many of these clients fear abandonment, and they may feel that the relationship with the lawyer is very different than the professional relationship that it should be. As a result, there are blurred boundaries. In other words, the client may feel that the lawyer is not just a professional assisting, but a friend. And when the lawyer does not return phone calls, the borderline may feel very abandoned and become deeply jealous and angry and even rageful. Borderlines often see things in extremes, all black, all white. So, one day you're a hero. You come in and you have your initial consultation with the client, or perhaps 2 or 3 meetings ensue, and then nothing happens for a couple of months, which is often the case with legal work. Court cases take months to come up. There's documentation review, and you as a professional lawyer, you have other cases, you have other clients. What happens? The client has not heard from you, and now they demonize you. You were a hero before, they put you on a pedestal, and now they demonize you. Now you're the worst lawyer in the world. And it can be very unnerving for the lawyer because, if you have a particular consistent relationship with your client, good, bad, or otherwise, it's at least somewhat consistent. But when someone idealizes you, one meeting and 3 months later, demonizes you, it's very jarring. It removes any kind of stability that you have, any sense of security or safety as a professional when dealing with clients. Many borderlines are really quite easily overwhelmed, and they don't contend with their problems on their own. They project out their fears and anxieties, and they can be quite impulsive and self-destructive in many ways. And they often are not only self-destructive themselves, but they undermine the lawyer's strategy, which may be very sound, and it could lead even to inappropriate legal advice or legal strategies. In other words, the lawyer may feel quite emotionally overwhelmed, physically unable to cope because the client is driving them crazy, And the lawyer will just give and say, okay, you know what, we'll do it your way, even though it's clearly the wrong way to go. Whereas what the lawyer should say is, you really need to be aware that you're calling me far too often. We need to have appropriate boundaries. And I feel like I'm a step away from giving you bad advice just so we can move this case along so that we can have a resolution to your concern. You don't want to do that. You want to make sure that you're maintaining your professional boundaries and professionalism within your own practice. Another important character type is the controlling type. Controlling characters, they tend to be quite preoccupied with details and rules. They tend to demonstrate perfectionism. They're unable to separate that which is really valuable from that which is not valuable. They can be miserly in their spending, quite rigid and stubborn, and they can be quite obsessional. Such clients may become so consumed with the unhelpful details of the case that the client prevents the lawyer from moving forward with the substantive issues that really need to be addressed. Another type is narcissistic personality. These are individuals who have to be the center of attention. Everything exists as an extension of their own ego. They require excessive admiration. They may have a grandiose sense of self-importance and a strong sense of entitlement. They may be quite exploitive in various ways. They may not be able to identify with the feelings of others and may be actually envious at times. They tend to understand their own needs as an extension or through other individuals. And in severe cases, you can even have malignant narcissism. Such clients may react with fury to legal setbacks in their case and routinely threaten to sue even when short delays are required for very good reasons. Why? Because everything in a narcissist's world has to do with their own ego, their own sense of self, their own self-importance, and their own self-esteem. And when that's injured just a little bit, or they perceive that there's an injury, they can really lash out. I want to tell you just very, very honestly from my own work doing forensics in thousands of cases that almost all the errors I have made are based on something called countertransference. Transference is a term borrowed from psychodynamics. When a patient is working with a therapist, the patient will have certain thoughts and feelings that arise while working with that particular therapist from the patient's background, often past meaningful or important relationships or events. But there's also something called countertransference, whereas the therapist will also have thoughts and feelings while working with that particular patient from the therapist's own background. You have this as lawyers, you have this as professionals. When I've made mistakes in my practice, it's because I have become angry. There's something in the client that triggers frustration in me, or anger, or disappointment. The client's taking up way too much time. The client's just not listening, and so on. And that's called countertransference, and lawyers should really monitor that. Lawyers should monitor how the client makes you feel. The lawyer should monitor if the client is making you feel in a way that doesn't seem right, or is making you feel particularly uncomfortable. And that is the key way to really diagnose a client who is difficult, who may sabotage your work. When the lawyer feels unease or nervousness, anxiety, fear, frustration, or anger without an apparent source, it is likely that the client himself has behaved or said something that has caused the lawyer's natural protective defenses to go up. We all have these triggers, and they serve as an early warning system that the person we are dealing with is somehow dangerous or a potential threat, or perhaps even somehow unbalanced. I just want to give a few suggestions as to how lawyers should deal with this before we end. Clarity of purpose. Make sure you're very clear and repeatedly clear with the client about what you can do and what you can't do, the purpose of your interaction with the client, the purpose of the application, whatever's going on legally, the goals, the aims, what the outcomes might be. Second, consistency of counsel. Allow yourself the opportunity when you see the client to reinforce what you said before in a consistent way so the client can hear the same thing over and over and digest the same thing over and over without hearing things that are different. Obviously, if there are changes in legal strategy that are needed or new issues arise, then clarity should be made for those issues as well, and they should be made as an extension or as a qualification to the original counsel, to the original matters that were being discussed. Always maintain appropriate boundaries. We see clients and we want to become friendly with them because we may have something in common with them. They're maybe just very easy to talk to, easy to work with. They may be very, very interesting. I see clients from all around the world. I saw a client last week who came to the United States. He barely finished high school, and he's doing extremely well in a car repair business. And I asked him how he did so well. He talked about his love of reading and developing himself intellectually. As I said, he's never been to college. And it was just, admirable about how he has done so well. And we talked about it, but it was important for me to remember that this is not going to be my friend. This is not going to be a social relationship. This is a professional relationship. And though I'm very impressed with his accomplishments, an appropriate relationship is needed. So those appropriate boundaries will in and of itself be very crucial when working with these kinds of clients. If there are conflicts of interest or ambiguities that arise, deal with them the minute that they occur. Don't allow things to fester and to grow. Don't allow the client to assume things or to develop assumptions in their head about the relationship or about the way the case is going. That is not only unhelpful and untrue, but don't allow the client to have that as a new mindset. Avoid that by addressing conflicts and ambiguities immediately. If need be, get a second opinion or ask yourself, what would a colleague with a very similar kind of case or client do? A client that calls every day, what would your colleague do? Or what kinds of interventions would they use in order to redirect the client so you can have a normal working relationship where you speak once a week or whatever is appropriate? Consider unfinished business. This is especially in cases that are going to end, a week or two or three or a month before. Ask the client or discuss with the client if there's any unfinished business. Are there any other issues the client wishes to speak about? This is also important before applications are submitted in civil litigation cases, immigration, criminal cases, and so on, to make sure that the fact pattern that you have from the client is complete. Careful documentation for lawyers. Make sure that you document what you're doing. Make sure that you're able to refer to your notes so that the next time you see the client, you're able to continue working with the client as an extension of previous visits based on your own notes and even documentation that the client gives you. Also, just be self-aware. Be self-aware that you're a professional, you're very educated, you know what you're doing, but you're working with not just facts, you're working with a human being, and that human being wants dignity, they want to be heard, and that's normal and that's appropriate, but you want to be self-aware to make sure that it doesn't cross over into a point where that client is being inappropriate, where the client's being too needy, and where that client may undermine your case or sabotage your practice in some way. One huge group where this is obviously important with are clients who are generally ashamed about talking about their cases, and it comes out piecemeal. These are clients who have been arrested and, they just feel terribly ashamed, and they don't fully talk about the facts of the case, and the lawyer is left without fully understanding what occurred, and therefore their representation is hampered. I see this with clients, who've suffered abuse, where they are too embarrassed to talk about physical or sexual, verbal abuses occurred, especially abuses that occur in public, and therefore the case is incomplete. Clients who've suffered extreme hardships in their childhood or traumas, abuses, and so on, may also be generally reluctant to have healthy relationships, even with professionals, because they've been perhaps betrayed in their past and their sense of trust has been harmed. You have clients who have really poor language skills, poor communication, adaptive skills, clients who may not have good English language skills, poor executive functioning skills, meaning they're disorganized, they don't process information as they should, and you have clients who may fear authority. So there's a whole range of reasons where people may have difficulty engaging with their lawyer in a way that allows them to present their case and then allows the lawyer to act in a professional manner. Well, thank you for listening today. This is a summary of how to avoid malpractice by understanding not just your own work as a professional, but clients who, for whatever reason, don't feel they're being heard. They don't feel that their dignity has been really attended to. They don't have a sensitive ear, they feel, from their attorney. But sometimes the attorney really is acting in a very, very professional manner. It's the client's fault because of their character pathology or whatnot, or they've been traumatized, and thinking about how to work with the client in a constructive way to calm them, to speak in language that they're able to feel that their dignity is being respected and that they're being heard. So a trusting, helpful, professional relationship can be developed in a way that allows the case to pursue in a professional way. Thank you.